अच्छा, बाइक वहाँ पे
Good afternoon, everyone. We'll wait for 5 more minutes for others to join, then we'll resume the class. Good afternoon, everyone. Let's switch your cameras on. Come on quickly, guys. Everybody switch your cameras on. Come on, Jasneet, Rachel, Jay, Stephen, Harsh, Ronak, Ritika, Mehak, Ikra, Uzma. Please switch your camera on. All right. Guys, please quickly switch your cameras on. We're already 15 minutes into the class. Okay. All right. So, how are you doing today? Any sleepy faces? Sunday afternoon, lecture time, laziness. All right. So, how many of you all have not completed and sent me the home assignment yet? I have received from 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. Received from only 13 people. Rest of you all? Yes, Suraj, have you done the home assignment? You sent it to me?
Yes.
Okay. Ganesh, are you joining for the first time?
Yes. First time. Today only.
Sorry?
Yes, today only I have.
Okay. Uh, Susmita, are you also joining for the first time?
Yes, sir.
Okay. How many of you are joining today for the first time? Ganesh, Sushmita, please raise your hands in the chat. So just the two of them. Okay, so you all can go to the recording of yesterday's class and you can ask me, let me know if you have any doubts or any clarifications required with respect to the lecture which we had yesterday. We had a brief introduction and we started off with a small discussion on business, political, and economic systems. We have covered the different types of legal systems as well. We started off with understanding the difference between civil and criminal law. We have gone through the details of what type of political systems are followed. With respect to Westminster model, I had given you all an assignment to check with it. So yes, tell me, what is Westminster model? Who wants to start? Yes, Zed, what is Westminster model?
Westminster model is when the executive is chosen by the parliament and he's also accountable to the parliament.
Chosen by the parliament. Okay. So in other cases, who chooses them then?
The public.
No, executive is never elected by the public. What is it? What is executive? Who is executive? What authorities form a part of the executive wing?
The officers who force the laws passed by the parliament.
Sorry?
The officers who force the laws passed by the parliament.
Okay. Yes. Anybody else to add on what is
I guess, sir, you are facing network issue.
I think network, uh, sorry guys, I think there's some network error. Am I audible now?
Yes, sir.
Yeah, sorry, we were discussing what is executive. Somebody else can add on to what is the executive wing of the government. Yes, Rachel.
So they constitute government ministries and civil services.
Okay. So, guys, executive is the wing of the government, which has the main role to implement the laws which are passed by the parliament. All right. So, in Westminster model, it is not that the executive is from the parliament. So you're right. It is from the parliament itself, from the government itself. So the main ministers, the main civil servants, the main part of the executive, the officers are elected from the government so that since they are also part of the policy formulation, they will be very well equipped to implement those policies themselves. So it's not that the executive is rather appointed by the people. Executive is always appointed by the government. But here, sorry, please excuse me. But here what happens is the majority of the executive part is elected from the government itself. So like for an instance, in our case of India, India follows the Westminster model. Uh, Majority of the ministries are appointed from the cabinet ministers itself. All the cabinet ministers are allocated one or two profiles portfolios each, and then they further add on to the civil servants in the list of the executive members, and that's how it becomes a formulation where the government and the civil servants come together and make sure that the functioning of the implementation happens smoothly. Are we clear?
So that is the type of governance module which is followed by a lot of democratic countries, called as the Westminster model. Any doubts, anyone? Are we clear? Yes. All right. Okay. Now coming to the home assignment with respect to your high court, the hierarchy of courts. One second, I'll just open one assignment so that you all can have a reference. A lot of you all have made a small couple of mistakes here, so I would want you all to correct it. Yeah, can you all see my screen now?
Yes,
Yes.
sir.
All right. So if you'll see over here, this is slight bit more of an elaborated differentiation and distinction of your code structure, but it covers most of it. The topmost authority is the Supreme Court, where only appeals at point of law are referred. Coming down next in line below the Supreme Court is the Court of Appeal. In the Court of Appeal, you get matters which are referred to appeal from the aggrieved party from the county court, the family court, the magistrate court. Now, okay, let's go from the bottom itself. The family court, the county court, and the magistrate court, these have their appeals laid down before the High Court. The High Court has 3 divisions, which we had discussed yesterday. From the High Court, the appeal goes to the Court of Appeal. And from the Court of Appeal, it goes to the Supreme Court. There is also an instance where the High Court can send its appeal directly to the Supreme Court, depending upon the facts and the case of the matter. All right. The Magistrate Court also may send its appeal to the High Court, which will then be sent to the Supreme Court. Or from the Magistrate Courts to the High Court to the Court of Appeals, and Court of Appeals to the Supreme Court. So a lot of you all have asked me that where have you all gone wrong? The only understanding gap which has come in is with respect to the flow of matters from the lower courts to the higher court. A lot of people have done what is from the magistrate court, they've simpliciter put it to high court. But from the magistrate court, the matters might also go to the crown court. So that is also an arrow which needs to be shown. All right. Am I clear? Am I making sense, guys? Yes. Anyone doubt? So everyone who I've mentioned that, that this needs correction, you all can refer to this, maybe take a screenshot of this, and then you all can have it corrected from your current existing chart. So these are the 3 separate other tribunals which are not part of your syllabus, but I've put in for the information purposes. So these are basically tribunals which deal with sometimes tax matters, insolvency matters, real estate matters, etc. Employment matters. So these tribunals are separately established under separate acts. So that is something which you don't need to go into so much of detail for, but just for a reference, I've put it there. All right, clear? Everybody's taken the screenshot? All right, okay. Okay, great. So we'll start with our today's portion. Everybody can see the screen?
Yes.
All right. Now, yesterday we dealt with common law countries, right? We understood what the concept of common law is, when it was brought into picture, how it deals and how it helps have a international unilateral justice system, right? Now, in common laws, one very important aspect that we dealt with was the role of judges, right? That the judges will not only decide the matters of law, but also interpret the law, correct? Now, when I say the judges will interpret the law, there are certain rules of statutory interpretation. When I say statutory interpretation, what I mean is that to interpret the statutes, they have certain rules. To interpret the understanding of law, they have certain statutes. And those statutes, those rules for understanding the statutes are laid down over here. So I don't need you all to learn each and every rule, but I want you all to understand what the rule is and then correlate when given an idea or a brief situation that, okay, this was the literal rule or this was the golden rule. All right. So you have literal rule, golden rule, mischief rule, purposive rule, elucidum generis, and expresso unis exclusion altris. So these are the 6 rules of interpretation. Clear? Now we'll get into each and every rule in detail. I am going to take in small examples for you all to easily understand. There are certain case laws also which are mentioned over here, which have applied those rules in the past. Literal rule technically means that you literally take the meaning of a particular term while interpreting the reason behind why it was mentioned. So you have to literally take the meaning of the word. You have to go by the word name itself, literally understand the meaning, and the dictionary understanding, the dictionary meaning is what has to be taken on the face of it. Yes. Stephen, could you please read this for me?
Okay. Literal rule. As per this, words must be given their normal dictionary meaning, even though the resulting judgment is undesirable. To better understand this, listen to this short podcast in Pinshorts, which explains a case in India where the court had to interpret the meaning of the term milk. Fisher v. Bell, 1961. The facts.
So how you read this is Fisher versus Bell, 1961. So this is a case law, the cause title of the case law, which is called as Fisher versus Bell, 1961. Now in this, you will have facts of a matter and what was held by the court as a decision. So it's a very brief summary of what the facts of the matter were. That is what was the main main issue which was proposed in the case. And then what was the decision held by the judicial system in that. Yes, please read.
Okay, so the facts of the case. The court had to consider the meaning of the word offer for sale. It was an offense to offer for sale offensive weapons. A shopkeeper had flick knives with price tags attached on display in his shop window. Held. The court applied the fundamental principles of contract law in a literal fashion, accepting that the display of flicking knives was an invitation to threat. It was the customer who made an offer to buy. In consequence, the shopkeeper was found not to be acting illegally. The aim of Parliament, however, had been to prevent sales of offensive weapons.
So what do you understand from the bare reading of the facts and the decision which was held? What do you think was the main idea behind the issue and then the judgment which was passed? Yes, Stephen.
I think it was the way that people interpreted when they saw a weapon that was displayed in the shop window. Here, people thought there was an intention to sell that item. So I think here the idea that people got was that the knife was offer for sale. And here what the court had, they had to go for the search of the definition of offer for sale.
Hmm.
And
So I'll just give you, there's one new concept here which I want you all to understand, which is offer to buy. So which is invitation to offer. Okay. Now, the court has applied a fundamental principle in the literal fashion, accepting the display of flick knife was an invitation to treat. Now, what does this mean? That if I am running a restaurant or a a place where there's people who come to eat, so I am displaying flick knives, as in a knife, to invite people to come for a treat. For an instance, to come inside and dine in my restaurant. But if the consumer gets misconceived and comes inside and gives an offer to buy the knife instead, which I deny, then is it my responsibility or is it the consumer's responsibility who has made that offer? So what the court has held over here is there was an offer for sale. Now, offer for sale means very simplicity. So the meaning which I was trying to understand, which was trying to help you all understand is, what is an invitation to offer? Now, we all know what an offer is. Offer is where somebody proposes something in return of something. All right. What is an invitation to offer? A simple understanding. You go outside Chroma and see iPhone 15 Pro flat at 50,000 rupees. And then there will be an asterisk saying terms and conditions apply. If you go inside that shop and if the shopkeeper says, no, I don't want to sell it for 50,000, it was just an invitation to offer, can you sue that shopkeeper for not providing you what he has offered outside? Yes. Can I go and tell Chroma that, oh, but you have mentioned outside that iPhone 15 Pro flat at 50,000 rupees? Can I sue Chroma for want of the offer?
No.
yes,
Okay. We have two opinions, yes and no. Anyone else? Okay, Mehak also says yes. For the ones who say no, why no?
Because there was this asterisk mark which shows terms and conditions applied,
Okay.
and the reader must not have seen the asterisk mark.
Okay.
So he must have gone there.
Okay. Stephen, why do you say yes?
I think because due to the display of the price, it created the invitation for the
Okay.
offer for
The
sale.
concept of offer is so we are going to read this in detail when we go to the next chapter where we are going to study about contracts. But just to give you all a brief is, the concept of offer is when I offer something, when I say I want to sell this phone for 500 rupees, are you interested in buying? If I send this message to Stephen, that means I'm giving him an offer to buy this phone for 500 rupees. Am I clear? Yes. Now, when I'm making an offer to Stephen, I am waiting for his acceptance or rejection. In the event Stephen says, yes, I want to buy. Or on the contrary, Stephen sends a 500 rupees note in an envelope to me. What does it mean? It simplicity implies that Stephen has agreed and accepted to the terms of my offer and he's willing to enter into the contract with me. Clear? So I made an offer to Stephen, which he accepted. So now I am bound to live by the terms of the offer that I've made. Why? Because that has converted to a contract at the time of acceptance from Stephen. Am I clear? Yes. Now, in a situation of the example that we've taken, Chroma is not making an offer when it says iPhone 15 Pro for flat 50,000. Chroma has put in an invitation to offer. Following which, when you go inside Chroma, you are making an offer to Chroma saying, okay, I want to buy it for 50,000. Will you give me? So if Chroma denies there, it is not that Chroma is in a breach of contract, because it was merely an invitation to offer. Like how in our case, the flicknicks which was there at display, if the wording said offer for sale, it does not constitute to be an offer. It is merely an invitation to offer. So if any consumer comes following this line, the consumer is the one who is making an offer inside. So the burden lies on the consumer who has made the offer to buy. And therefore, the shopkeeper in our situation was found not guilty and was not found to be acting illegally, because the aim of the parliament was not to abandon or restrict the usage of knives for inviting people to come and dine. It was merely for prevention of sale of offensive weapons. So the intent of the act was saved. Was there any sale which took place? No. Therefore, the court held that the shopkeeper is not guilty. Are we clear?
So
Yes.
so then how are we to differentiate between cases like this and cases of false advertising?
False advertising is a completely different pretext, where if I show you this phone, which has 3 cameras in the advertisement, and when you buy it, you get a phone only with 2 cameras.
Do cases of false advertising not include where you're selling it for a different price?
Different price will also be included, but when it is said that there are terms and conditions which are attached to it, you cannot blame the consumer, the seller for it. If you will see, most of the restaurants have written in their menus and their terms and conditions at the entrance, we reserve the rights to admission. Most of the parking lots, right, park at owner's risk. What is all of these? All of these are their defenses. That if tomorrow something goes wrong, if today you go to a restaurant, very simple example. Let's say you go to a restaurant and you read the menu, and the menu says they have a pizza in it. Right? You call the waiter and you say, can I have a margarita pizza, please? The waiter says, sorry, we're out of bread. I will not be able to serve you margarita pizza. Do you sue him for false advertising that you have mentioned in the menu? Why do you not have it? So the menu card is an invitation to offer. When you have the menu card, the restaurant is inviting you to come and make an offer. And when you place an order, so see, this is such a beautiful version of a contract which we don't even realize, but on a day-to-day level, we are entering into one. When you go to your college canteen and you ask him if you can get a vada pav, you are making an offer which he is accepting by saying, okay, I'm placing your order for 1 vada pav. Does he ask you, will you pay me money? No, right? It's an implied understanding between you and your canteen vendor, or you and the restaurant when you place an order in the restaurant. That when you are placing this order, you are agreeing to make the payment as per the terms and conditions of that restaurant. X is the price, Y is the tax, Z is the service charge, and total is this. So false advertising is obviously a thing. I don't deny that. But there are a lot of defenses which come in at the time of false advertising. I am absolutely 110% sure you will not come across any signboards or any offer boards which do not have an asterisk on the top. If nothing, they will write below. In fact, even on your newspaper publications and all of that, if you'll see, the first page is filled with the huge display of the mobile phone, televisions, etc. Get this at flat so and so price. And then when you go down, it says this price includes an exchange price of up to rupees so and so for this model and above. This price includes GST discount of XYZ amount. This price includes HDFC card discount for so and so amount. So these guys are very smart when they make these invitations to offer. Another simple example. If you go for a amusement park, let's say Imagica is an amusement park, you go for the amusement park. You pay the price of the ticket and you buy the ticket. Now, the concept of this national amusement park is that you get an entry for just rupees 50. This is a hypothetical situation. You have to pay rupees 50 for the entry, and then each ride you have to charge, they will charge you separately. All right. You go towards one ride, and that ride is not functional. Will you sue the amusement park? Why not? You have paid for the entry to that amusement park, but that amusement park is not giving you what you had come for. So if you will read and the terms and conditions of the amusement park, it would have been mentioned that they reserve the right to restrict the entry to any of the rides for safety and security reasons. For technical issues, they will not allow you to get into the ride. They reserve these rights. And that's where they get saved from false advertising. Clear?
Yes, sir.
Is the little rule clear, guys? Okay.
Yes, sir.
Move on to the next point. Golden rule. Now, golden rule is where the literal rule gives more than one meaning or provides an absurd result. The golden rule is used to ensure the preference is given to the meaning that does not result in the provision of being an absurdity. Kya bola? Itna do line very confusing. What it simplicity means is that when one particular word has more than one meaning, the most relevant meaning is the one which you have to choose. Now, very simple example we can take that there are two types of bins. One is your laptop's recycle bin and one is your dustbin. Clear? Now, for an instance, Ayan calls me up. Sir, the file that you showed me in the class with respect to the hierarchy of chords, I'm not able to trace it. Where do I find it? I said I had saved it in your laptop. Sir, I'm not able to find it. Ayan, please look for it in your bin. This is a sentence which I make. Ayan goes to his kitchen, opens the drawer and starts checking it inside his dustbin. Does this make any sense? Bin means both the options, right? Your trash can bin of your recycle bin and your dustbin. So here the law states that you have to very particularly select the meaning with the utmost relevance in that pretext. Clear? So today, in a situation where there are multiple meanings coming out of a phrase or a term or a particular word, it's the job of the court to make sure that the most suitable meaning has been taken into consideration. Yes, sorry guys, am I audible now? I think there's some network error again. Sorry.
So,
Yes. So, yeah, Stephen, you were to continue reading. 1 second, I'll just share the screen. Yeah.
Okay. Adler v. George, 1964. Facts of the case is a conviction was challenged on the basis of what appeared to be miswording in the Official Secrets Act, 1920. The act made it an offense to obstruct a member of the armed force in the vicinity of particular locations, but not actually in those locations. The defendant was actually inside an Air Force base at the time of the incident, which he claimed was beyond the literal scope of the act. Held the word in the vicinity of a prohibited place in the Official Secrets Act were held to cover the acts of the defendant which took place within a prohibited place.
So here the example is very simple. There was an act which was passed which said that, sorry, where is it? In the vicinity of particular locations, you cannot be using any sort of forces, your weapons. All right. Now, there was a conviction which was there where a person challenged this, saying that I was in a particular location. The act says in the vicinity of. Now, when you literally go by the literal meaning over here, what will it mean? In the vicinity of means around that area. So very smartly, the defense has tried to take a stand saying that you have said in the vicinity of, but not actually in the location. Right? So the court applied the golden rule here, saying that if I say, let's take a different example from this. Honking is not allowed in the vicinity of a school. All right. I go inside a school and I start honking my car. And I say, boss, what did the law say? That in the vicinity of the school, you cannot honk. In or around the school, you cannot honk. There is nowhere it says that inside the school, I can't honk. So the court holds that the entire purpose was to prevent disturbance to the school by way of sound of honking. Now, if you go inside the school and only honk and then take the defense of saying that it was said in the vicinity of the school, it's not allowed, then the entire purpose of making this goes to waste, right? Therefore, the court went ahead and chose the most appropriate meaning of the term and applied that. Am I clear? Any doubts, anyone? Yes, Susmita, you've joined for the first time, right? Are you getting on what we are trying to explain and what we are dealing with over here? Any doubts? Okay, all right. So we'll proceed to the third rule. So we've done two rules up till now. One is the literal rule, where the literal meaning is applied. Second is the golden rule, where the most relevant meaning out of the two to eliminate absurdity is applied. Third one. Now, make sure that you keep in mind that a lot of these rules will be overlapping. Sorry. So what will happen is the meaning and the terms of these interpretation statutes, the rules of statutory interpretation might overlap with each other, but that does not mean that you will only have to apply one. Sometimes the courts might end up applying two rules at once also in order to reach to a final decision. Clear? The third one is the mischief rule. Now, what are the two rules that we've done till now? Literal rule, literal meaning, golden rule, eliminate the absurdity and use the most relevant meaning. Clear? Third one is a mischief rule. Now, this mischief rule is used to interpret a statute in a way which provides a remedy for the mischief the statute was framed to prevent. What does this mean? Mischief का मतलब क्या होता है? Mischief means anything which is a wrongdoing, which is not accepted by the courts of law. Yes. Guys, please switch your cameras on, everyone. Ronak, Harsh, Ishita, Ganesh, Mohit, Tanvi, Ramya, Jay. Quickly, guys, come on, switch your cameras on. Yes. All right. So I was at the part of mischief rule. Now, what does a mischief mean? You know, in school, you might have heard, in your home, you might have heard, do not do mischief. What does it mean? It means an act which is not allowed, which is a wrongdoing. So the mischief rule is used to interpret a statute in a way, simpliciter, I have to punish and accept the remedy which is for the act was framed. For an example, if suppose, let's say that there is an act which prohibits use of knives. Correct? Use of knives for what? For killing people, for stabbing people, for violence, right? If tomorrow I'm using a butter knife on my bread, can I be punished for that? So, but the law says that use of knife is prohibited. So your mischief rule applies, and you will only punish the people who are actually doing the mischief for which the law was prohibited. Another instance we'll take. Let's take an example of jumping a signal. All right. So the law states that wearing a helmet is compulsory and you cannot jump the signal. Clear? Now, today, if there is a car which is over speeding, but has followed the signal light, but from the right hand side, a bike is coming, which has a rider which is not wearing a helmet, and they meet with an accident. Who will be responsible in this situation? The person riding the bike or the car owner?
Both.
Both will have a contributory negligence in this. But in this situation, the entire remedy for somebody over speeding was to prevent accidents. And the person riding the bike without the helmet was also to make sure his safety is secured. So here in this situation, it is a wrongdoing, a mischief on the part of both of the people. And therefore, both will be equally punished under the cause of contributory negligence. Both of them had some sort of negligence in this thing. Clear? Now let's read the case law that we have. Yeah, continue reading.
Okay. So the case is Goris versus Scott, 1874. The facts of the case was the Contagious Disease Animals Act 1869 provided that any ship carrying animals should contain them in pens. The defendant neglected his duty, and some of the claimant's sheep were washed overboard and lost. Held since the purpose of the statute was to prevent the spread of contagious disease and not to guard against the danger of the property being washed overboard, the claim failed.
What do you understand by this, Jay?
Sir, can you explain the meaning of pens? What is pens?
Pens means cells, your
Cage.
cages.
Okay. So the fact is that it was necessary to keep the animals in cages while transporting them, I guess. But the defendant neglected his duty and didn't keep his animals in cage.
So then why did the claim failed?
The claim was to prevent from spread of any contagious disease, not to safeguard any animals.
All right. So, Jay has rightly pointed out. I'll just give you a brief about what the story is. There is an act which has been brought into picture for prevention of spreading of contagious diseases from the animals. Now, there is a ship which is carrying animals, and any ship which carries animals, the act provides that they should put those animals inside cages so that the contagious diseases are not spread, right? Now, what has happened in this picture is they have failed to keep the animals inside the cages, and they washed a few animals, and in that, a few animals got lost. So now the claim is that you were required to keep the animals inside cages, and you failed to keep them inside cages. So therefore, I am imposing a penalty on you. All right, which ideally makes sense. What does the law say? The law says that you have to keep the animals inside the cage. If they are not inside the cage, you are supposed to be levied with a penalty. Why? Because those are contagious animals. They can spread contagious diseases. What the court has held over here is that your issue, the cause of action, is not spread of contagious diseases, is that your animals are lost. So the rule was not to keep them in cages so that you prevent them from getting lost. So the mischief rule here is applied, saying that the mischief which has taken place is not the intent of the act. You may have a civil claim which you have won before any civil court, but under the Contagious Disease Animal Act, you cannot come and claim here. Am I making sense, guys? Yeah. And that's why the claim was rejected. So what are the three rules that we've studied till now? Literal rule, golden rule, and mischief rule. Literal rule is what? You apply the literal meaning. Golden rule, absurd meaning is scrapped down and the actual understanding of the context is taken into consideration and the meaning is considered. Third one is the mischief rule, where you only punish the person for the mischief which is mentioned in the act. Clear? Next one is purposive rule. Purposive rule is a modern approach wherein court passes a judgment based on its interpretation on what was the interpretation of the parliament while passing the statute. Now, this is very important. Why? Because the purpose of the act is to be considered. Now, this sometimes overlaps with mischief rule as well. Because if you see the previous example that we had taken, you have also applied the purposive rule over there. The purpose of the act was to save spread of contagious diseases, not to prevent your animals. Similarly, in this situation also in a purposive rule, you have to make sure what the intent of the parliament was while making that law. And when that intent is considered, and if there is a breach of an contract or an act which is committed, which is ultra vires to the intent of the parliament. When I say ultra vires, what do I mean? Which is against the intent, which is going against the main reason why the parliament passed that law. Clear? Let's read the example. The facts of the matter are the purpose of an act was to provide for safe storage of film wherever it might be stored on premises. The claimant argued that premises did not include a cave and so the act had no application to this case. Ab kya hai ye case? I'll give you a very simple understanding of the case. I am a movie director and I am told that there is an act which is in existence in the country which says that wherever I store my film, the movie, that premises has to be safe. All right. Now, when I use the word premises, what comes to your mind? Office premises, building premises, society premises. Would you think of a a cave or a forest as a premises? No, right? Nobody would, in their ideal sane mind, think of a forest or a cave as a premises. But what was the intent of the act? The intent of the act was wherever I store my movie, my film, that place has to be safe. So if I'm storing that movie in a cave, then that cave also has to be safe. Fair enough? Because the intent of Parliament was what? The intent was to keep the film safe. The storage of films stay safe. It did not intend with respect to where I am keeping it. And therefore, the purpose of Act was to protect the safety of persons working in all places where the film was stored. So if the film is shot in a cave or a forest, then it is my responsibility to make sure that there is safety. And therefore, the court held that the term premises will include the word cave in it. 4 rules that we've learned till now: literal rule, literal meaning; golden rule, eliminate the absurdity and use the main meaning; mischief rule, the mischief for which the act has been made, only that remedy can be claimed; purposive rule, don't forget the intent of the parliament. 4 rules clear? Yes? Yes, Justine, what are the 4 rules?
Literal rule, golden rule, mischief rule, and purposive rule.
And what is mischief rule? What is golden rule?
Golden rule is where you observe the meaning of what you have done, and mischief rule is that you are punished for the you are uh, punished for the mischief you have done.
So, golden rule is you eliminate the absurd part.
Okay, you will know that.
Yeah, you don't consider the absurd part. You only consider the relevant part. Mischief rule is you will only be punished for what mischief you've done if that act is intending for. And purposive rule is you don't forget the intention of the parliament in passing the statute. Clear?
Okay. Yes.
All right. Now the rest of the 2 terms are as easy as the complexity of the word is. Elucidum generis. एक सिंपल सा एक एग्जांपल लेते हैं. I ask Drishya to go to the market and get me apples, mangoes, bananas, and other things. Drishya, what will you go and get for me?
What you mentioned, apples, bananas, oranges, other. Oh, okay. Is that what you're asking? Like,
So when I tell you, Drishya, go to the market and get me apple, banana, fruits, and other things. Apple, banana, oranges, and other things. So what am I intending? What am I implying over here? What do I want you to get for me from the market? Fruits, right?
Yeah, fruits.
When I say apple, oranges, mangoes, and other things. So you might probably get some more grapes or peaches or oranges or mangoes, right? When I say other things, that is what will come to your mind.
Yeah.
When I say other things, can I expect you to get me a ball pen also? But I said other things, right? So other things could include anything.
But it's ambiguous in meaning. Other things could mean something for you and something for me.
Deriving that I'm talking about fruits? Because the preceding 3 items that I've mentioned are somewhere around fruits.
Yeah.
Yes. So no person in his sane mind will be able to assume what I'm trying to say when I ask for a ball pen whilst I'm talking about the 3 fruits. right? So here when I talk about other things, I'm actually focusing on the three things which are earlier. And it is on the basis of the three things earlier that I've mentioned that you will consider the ambiguous fourth thing. Am I making sense, guys?
Yeah.
So what does this rule say? This rule states that the general words mean the same purpose as the specific words they follow. So if I ask Stephen to go to office and get me pen, pencil, eraser, stapler, and other things, I can't expect him to get my lunchbox. Because the 3-4 things earlier that I've mentioned are pertaining to stationery. Right? Yes, let's read the act, please. Yes, Drisha, continue reading.
So, Powell versus Kempton Park Racecourse Co., 1899. The facts are Section 1 of the Betting Act, 1853, prohibited betting in a house, office, room, or other place. The issue was whether a ring at a racecourse was an other place for the purposes of the statute. Held, the Lords decided that if the Ius Dem Generis rule was applied, the specific words such as room and office that preceded the general phrase or other place created a class of indoor places. As a ring on a racecourse was outside, it would not fall within this category. Therefore, the Act did not apply to restrict gambling here.
So it is very well understood now from the example that I gave earlier what this rule of statutory interpretation means. The general terms which follow the specific terms, they will only be in context of the earlier terms. Here in the example, it says house, office, room, or other place. Maybe my bedroom could form a part of this. Maybe my building premises could form a part of this. Maybe my washroom could form a part of this. Maybe my kitchen could form a part of this. But there's no way that a racecourse ring will form a part of this. Right? So therefore, why did the Ius Dem Generis rule, the accused was acquitted? Clear? Now the next one is expressio unis exclusion altris. What does this mean? This also very simpliciter means that anything which is not expressly included in the list is specifically excluded. If I ask Drishya to go to the market, I give her a list of 10 items to get from the market. All right. Out of there are only and only chances that I can claim from Drishya is those 10 items. I cannot expect her to get anything apart from those 10 items. Or else then what is the purpose of the list? So anything which is a part of the list is what is supposed to be included. Anything which is not a part of the list is simpliciter excluded. Clear? So 6 rules of interpretation. We start from literal rule, literal meaning, golden rule, eliminate the absurd meaning, mischief rule, you get punished only for the mischief when you are intending to do that mischief with respect to the act. Fourth one is purposive rule. Don't forget the intention of the parliament. The parliament's intention is to be taken into consideration. What was the purpose of implementing that act? Next one is Ius Dem Generis. General words which follow the specific words will only mean around that. And the sixth one is expressio unis exclusion altris. Anything which is not a part of the list is considered to be specifically excluded. Are we clear, boys and girls? Any doubts, anyone? Am I sure?
Yes.
Yes.
Okay, all right. Now there are presumptions. What are these presumptions? These presumptions are that these are those presumptions which are generally applicable unless the legislation specifically states otherwise. So all citizens of India have to abide by the rules and regulations made by the state. That means that even a senior citizen is included in that. Even a newborn baby is included in that. Yes, unless and until I make a specific remark that all citizens apart from the senior citizens. So it's a presumption that all citizens have to abide. A statute does not alter the common law. So if, let's say, a country is making a statute which is intending to alter something, that will only be for that particular state or that country. The common law system cannot be altered by a statute. A statute does not exclude the jurisdiction of a court. So there is no law which can be brought up in India which says that there is no court in India which can try this matter. Legislation does not extend beyond the territorial jurisdiction of UK or any particular country as such. So today I can't make a rule for Pakistan government or for the people living in Pakistan. Of course, unless it's talking about your citizens who are residing outside, NRIs, it's a separate deal altogether. A statute will not bind the crown. There is no law which can bind the crown, the Queen of England, to do something, or in our country, in our case, the President of India. Laws will give you what rights and power the president has, but it cannot bind the president to do something. Of course, duties are a separate role and deal altogether. And of course, this does not include a fact that, if they are holding that position, they can murder anyone, they can do anything they want. Always remember this very fun fact. No president can be sent to jail while he is in the position. If you want to sue that person, you first impeach the president and then start the proceedings against him. So if you someday intend to kill someone, or if someday, Rishya, with your gun, you want to shoot someone, first become president and then shoot. Or else you will be subjected to very stringent trials. All right? Okay. A statute does not have any retrospective effect. Okay, fun fact. If today I am riding Activa without a helmet, and tomorrow the law comes that riding of helmet is compulsory, can a police officer click a picture of mine today, which is clicked today, use it tomorrow saying, oh, yesterday you were not wearing a helmet?
No.
So when I say retrospective effect, what I mean is the laws cannot apply to earlier acts. It will start from the day it is passed. Clear? Anyone, any doubts, any difficulties with respect to the 6 rules?
So
Okay.
what is statute?
Statute means an act, the law. Okay?
Okay, sir.
All right. I'll take a short 10-minute break. We'll come back at 3:30. In the meanwhile, what you have to do is read these 6 rules again. And if anyone has any sort of doubts or difficulty, we can discuss again. All right. We'll meet at 3:30 dot. Yes, guys, let's resume. Please switch your cameras on, everyone. Okay, anyone, any doubts with respect to these 6 rules that we've just gone through? Quickly, guys, switch your cameras on. Jasneet, Stephen, Ayan, Tanvi, Rachel, Mohit, Simran, Harsh, Ronak. Drishya. All right. So shall we move ahead now, guys? Yes.
In pre-assumption, the fourth point, right?
Presumptions, the first point.
Fourth point.
Fourth point, a statute will not bind the crown. So like I said, no, the crown is the royal majesty in UK. In India, the equivalent position is the president. So there can be no rule, no law which can bind the crown to do anything or refrain from doing anything apart from the duties and responsibilities. Clear? All right. So we have 2 quiz questions. If an act says that the sale of milk, curd, cheese, and other things is prohibited in a medical store, is the sale of buttermilk allowed? Yes, as it's tasty. Yes, as long as certified by the food agency. No, as it's an edible item. No, as it's a milk product. So the answer will be D.
Yes.
The rule says that the common things which follow have to be gone and considered on the basis of the 3 things which I mentioned earlier. If an act says that one must not dispose of rubbish in public places and the claimant claims that his friend talks rubbish, out of the different meanings of the word rubbish, the court interprets it as waste material. What's the statutory interpretation here? Right of a person to have friends who don't crib about their ex. Literal rule, get a life, you lose an act. Golden rule. So the answer will be
Golden rule.
don't underestimate the options. They are not going to be so easy in your exams. But of course, you will have at least 1 or 2 options which will simpliciter be ruled out. So for an instance, if you take the first question, it's a yes or no question, right? So when you know that the answer is no, immediately 2 options get eliminated. So you only have to choose the reasoning from the one of the 2, right? All right, moving on. Now we are done with understanding the common law aspect of it. We'll start off with the civil law part. Common law was one of the legal systems that we studied. Civil law is the second legal system, and the third legal system is going to be the Sharia law. Clear? 3 legal systems are a part of your syllabus, which are the major types of civil systems, legal systems which are followed across the world. Civil law. Now, the difference between common law and civil law is something which is of your utmost importance, because if you understand common law and if you understand the difference between civil and common law, understanding of civil law will become very easy for you all. Civil law, the major difference between common and civil law is going to be the role of judges. Nakul, what was the role of judges in common law?
Sorry, sir.
What was the role of judges in common law system?
They have to the hierarchy.
That is the legal judiciary. I'm talking about the role of judges. What does the judges have to do in common law?
They have to maintain the decorum, like someone is following or not.
Correct. So basically they have to interpret the law and then make sure that the law is being followed on. Correct? On the contrary, in civil law, the judges do not interpret the law. They will simply just make sure that the law which is in picture is being applied or correctly or no. So in general terms, the judges are not supposed to interpret the law, but simpliciter apply it. Clear? This is the main difference between civil law and common law. Another difference is that civil law is originated and developed from the Roman Empire, whereas common law has originated from UK, England. Clear? It is historically developed from the Roman law. Principles of civil law are comprehensibility and certainty. Laws are contained in codes. They are framed as generic principles applicable in any situation. Laws should be decided predictably in reference to the above mentioned codes. Sources of civil law. Now, the constitution of that particular country is, of course, one of the biggest sources of civil law, because the constitution is where you get the laws from, where you get your, it's basically the roots of your judiciary. European Union laws, statutes, administrative regulations, and customs of the land. These are the 5 sources of civil law. Now, like we discussed, the role of judges in civil law is that judges only apply the law. Judges create precedents which need to be followed by other courts. So, your doctrine of judicial precedent followed in both civil and common laws. Judges are not supposed to interpret the law generally, but in situations where it's of utmost importance, the judges will end up implementing the law and going into the details of interpreting the law. However, when interpretation is required, judges may identify the social and historical purpose of the law and apply it. Like I said, only in situations where it's required, utmost importance is there, only then the judges will interpret the law. Clear? Now, since interpretation of judicial statutes is restricted to judges in civil law, there are principles on the basis of which they can interpret the law. First one being, in general terms, judges are not supposed to interpret the law but apply it. However, when some interpretation is required, judges are required to identify the social purpose of the law and apply it in a manner that ensures the purpose is enacted. So you have to keep in mind the purpose of the act. Again, taking us back to the purposive rule. Clear? Judges may look at the historic intention of the law and seek to apply it in a way that it would have been drafted to cover the modern situations. The only problem which these guys face is that the law has been enacted back in hundreds of years ago. But the situations are modern. So they have to bring a balance between the time when they had enacted it and the modern situations, and that's when they interpret the law. Clear? Any doubts? Anyone? Yes? Okay. Drishya, please read the differences for me. Common law and civil law.
Common law, the origin is in England, whereas civil law origin is in Roman law. In common law, judges can interpret the law, whereas in civil law, judges are not supposed to interpret the law, only apply it. In common law is used in England, India, USA, etc. Civil law is used in Germany, France, etc. In common law, as judges can interpret the law, it is more flexible and can adapt to justify the case. Civil law is not very flexible, but is firm.
Yeah, it's firm. Why? Because judges are not supposed to interpret it. You have to just follow what is mentioned in the law. Clear? All right. Arrange the British courts in order of their hierarchy. So which one will be the topmost?
Supreme Court.
Then comes the
Court of Appeal.
and then the Crown Court and the Magistrate Court. Clear? All right. The last legal system that we are going to study today and understand is the Sharia law. Now, Sharia law is based on Islam, the Islamic law. The Islamic countries which are very religious in nature, and the country is not a democratic country, but an Islamic country where the government is appointed on the basis of the Sharia law system, are the countries like Saudi Arabia, UAE, Kuwait, Pakistan. So here the dominance of Islam is very high, and therefore Sharia law is the system which they follow. Sharia law is based on Islam. It is given by Allah. It is used in several important countries like Saudi Arabia, UAE, Kuwait, Pakistan, etc. Now, what are the sources of Sharia law? Now, unlike the other generic sources of law with respect to civil law and common law, sources of Sharia law are, the roots are rooted to its Islamic background, the religious background, which comes from the Quran, the Sunnah, the Madhab, and the constitution of the country. Now, Quran, I'm sure everybody's aware, it's the holy book of Islam. Yes, Allah's divine message to Prophet Muhammad. Sunnah is the record of what has come to be acceptable course of conduct derived from the sayings of the Prophet known as the Ahadith. So basically, their spiritual gurus are the ones who are considered as Ahadiths, and Sunnah is the record which is acceptable course of conduct, what you can do, what you cannot do, as per the sayings of the Holy Prophet known as Ahadith. Okay? Madhab is the school of thoughts based on teaching of Islamic jurists. They are broadly divided in two schools, Sunni and Shiite. Now, the Sunnis form the majority of the population, and the schools under Sunnis can be further subdivided into Hanafi, Maliki, and Shafi, and the Hanbali school. Now, I don't want you all to memorize each and every name, but I want you all to be acquainted to these terms. So if at all you read somewhere, you need to know what Sunnah is, what Madhab is, right? And of course, the constitution of the country, very important source of getting the understanding of the laws and statutes of the country. Any country, the wholesome guide is going to be the constitution. Clear? Now, we have realized that the difference between the legal systems generally is on the basis of what is the role of judges, right? In common law, judges interpret the law. Civil law, they just apply the law. In Sharia law, similar to that of civil law, judges are simply clerics. Some countries also have secular clerics. It's not important to have only Islamic clerics, but they are simply clerics who apply the law. They are not supposed to interpret the law, because as per the holy book of Quran, what the Islamic religion believes is whatever was to be interpreted has been interpreted by Allah. And if at all there is any further thing which is required, then it's the Prophet who will help you with interpreting the same. Judges only apply the law. Power of interpretation is limited as the law is established by Allah himself. So the belief of Sharia law system is that since the God himself has jotted down what is important and what are the laws and what are the statutes, you don't need any further sort of clarifications or interpretations in it. Clear? So now that if the judges are not allowed to interpret the law, where do you get the interpretation from? How do you realize what is the correct interpretation of this? So if a clear guidance is not available in Quran, a cleric may refer to Sunnah to confirm, explain, or clarify the law. Clear? Like I said, Sunnah is who? Sunnah is the Prophet who is known as the Ahadith. Yeah. Moving on. If within the Sunnah, Ahadiths are classified according to their reliability. Muwatatir are virtually guaranteed. Mashtur are less certain, and Ahads have little certainty about the reliability. So this is the probably a hierarchy which they follow of who is more reliable as compared to the other. Moving on, there is a controversy in the Muslim world whether further interpretations of law may be required or not. Because of course, with changing times, evolving times, there has to be a situation where you need room for growth, development, and amendments now. Because back in the time when this law was created, the situation, the surroundings were very different, and now it's very progressive. Clear? Any doubts, anyone up till now? I want you all to only simpliciter understand the difference between the three legal systems and a gist of what these legal systems are and what the role of judges are. There is a Taqleed is the theory that the law has been interpreted sufficiently and does not require further interpretation, which is why they don't believe in the judges having to have the role of interpretation of the law. Ijtihad are the historic processes used for interpreting the law. The specific type of ijtihad are ijmas, qiyas, istihan, masla, mursala, urf, and istisham. Now, these terms are probably slight bit confusing for you all. So I don't need you all to memorize each and every term. But what you can do is you don't need to remember each and every term, but you have to only be acquainted with these terms and these names. Okay? All right. Tanvi, am I clear? All right. Moving on. Ijtihad must not be carried out on certain matters such as where Allah exists. So ijtihad basically kya hai? Ki you cannot raise a question or interpretation of whether Allah exists or not. Because that is the divine force which is guiding everyone under Sharia law. Ijma is a consensus of opinion of jurists. So it's basically you have like how we have the cabinet of ministers in the regional setup. As per their religious beliefs, they have a opinion of the jurists who are considered to have known, very well read, and are very well aware of the Quran. Qiyas is a comparison of two things with a view to evaluate one in the light of the other. So when there is confusion, when there is some sort of room of doubt, you compare the two situations and then come to a conclusion. Istihan is the concept of equity or fairness exercised with the bounds of what Quran says. So it believes in equality, fairness, equity, and on the terms of what Quran says. Am I clear, guys? Any doubts? Anyone up till now? Now, in Islamic law, charging interest is something which is prohibited, which is considered as a taboo and a illegal act. So riba is an unjustified increment in borrowing or lending money paid in kind or in money above the amount of loan. So basically they're talking about is interest. Clear? Judicial review may exist in some Muslim countries to ensure that issued state statutes are based on Sharia law principles. So when they feel that, some principles are going off track and beyond the scope of Sharia law or are not following what the Quran says, they will go for a judicial review. Clear? Any doubts, anyone?
Sir, just one question.
Yes.
If in Sharia law the judges can't interpret the law, then does that mean they don't follow judicial precedent?
So the reason for not allowing them to interpret the law is because they believe that everything what is to be defined, interpreted, has already been done by the Almighty, that is Allah. Now, since Allah has already decided what needs to be done, what does not need to be done, your following of precedents does not come into place. Because earlier also you might have followed Quran only. Now also you will follow Quran only. So there is no interpretation of law which a court needs to do. And since the court need not interpret the law, there will be very less situations where you will actually need the court's assistance for an issue which is similar to a previous issue. Because if the previous issue was decided in a certain way, it would have been decided by Quran. So even now it will be decided by the Quran. There will be no room for confusion where there will be ambiguity.
But sir, there must be some cons in this law also.
See, every legal system has its own pros and cons. The cons of this system, if in my opinion I was to say, will be simpliciter, the ones which even countries like India are facing. Regressive thought process, regressive mindset. So it's not necessarily because it's following a religious holy book that issue is there, it's because of the mindset of people. Sorry. So with changing times, all countries which have a progressive, regressive mindset have to evolve, develop, and adapt the modern issues so that they can bring modern solutions to them. So all these countries are also slowly and steadily evolving, developing, but their basis remain the Quran. Am I clear, guys? Yes, no,
Yes.
Yes.
Yes, sir.
doubts, anyone? Any issues up till now?
No, sir.
Okay, shall we move on
Sir,
then? Yes.
sir, interpretation of law means reframing the law, na? According to the situation.
Interpretation of law means you decide the ambiguities in law. So when you are unable to understand why such a law is passed, or when you are unable to determine the end result of that law being passed, you yourself as a judge will go into the details and go back to the part when the law was passed, correlate the two, and interpret as to why this law was passed and is it relevant over here or not. And if it is relevant, how do you modify it? Clear?
Yes.
Anyone, any other doubts, difficulties? All right, so this brings us to the end of our first chapter. And sorry, once again. Yes. Let's just quickly go through a small recap of what we've done. But before that, please switch your cameras on. Ayan, Jay, Ronak, Simran, Rachel, Jasneet, Harsh. All right. So what are the three types of economic systems that we studied? Planned, mixed, and market. Planned is where most of it is held by the government. Mixed is where government and private entities have their own set of force. It's a mixed bag. Market is where the market forces, that is the private entities, hold up the majority of the market space. Guys, please, yaar, don't make me do this again and again. You all are switching your cameras off. It's distracting me because the screen goes off immediately. So keep your cameras on, everyone, or else you can leave the meeting if you want. Yeah. The three types of legal systems that we studied: common, civil, Sharia. Three main important parts of the differentiation is common law, judges interpret the law; civil law, judges only apply the law. At very rare instances, they will interpret the law. Sharia law, they do not interpret the law, they are merely clerics. Government machineries, which we've studied: judiciary, executive, and legislative. Legislative is the one which makes the law, executive executes the law, judiciary makes sure that the law is executed correctly. Three approvers of legislation in UK: House of Commons, House of Lords, Royal Assent of the Queen. India, it is Lok Sabha, Rajya Sabha, and the President. Hierarchy in UK: Supreme Court, Court of Appeal, Civil Division, High Court, Queen's Bench, Chancery Division, Family Division, County Court, Criminal Division, Crown's Court, Magistrate Court. Clear? 6 rules of statutory interpretation. Literal rule, you apply the literal meaning. Golden rule, you eliminate the absurd meaning and apply the most relevant meaning. Mischief rule, you only get remedy for the mischief which is mentioned in the act. Purposive rule, do not forget the interpretation, the purpose of why the statute was incorporated in the first place. Aeris dim generis, the general terms which follow the specific terms, they apply the same pretext. Expresso unis, exclusio altris, anything which is not mentioned in the list exclusively will be considered to be specifically excluded. Clear? Here, please make one change. There is a typographical error. you have to make this to common law and Sharia law just do not interpret the law को change करके civil law and Sharia law do not interpret the law. Civil law को यहाँ पे change करके make it common law, please. There's a typographical error in your books. Please have it corrected, so that there's no room for confusion later on. Clear? All right. So this brings us to the end of your first chapter, business, political, and legal systems. Any doubts with respect to the entire course, guys? All right. Take 5 minutes, go through the book, read the entire, just skim through the topics. And if there's anything else, you can get back to me. I'm keeping the camera on. Everybody keep your cameras on. Just go through the topic once and then get back to me if there's any further doubts. Everybody has their notes. You all can refer to the same.
Sir, done.
Everybody else done? Any doubts?
So,
Yeah.
the clerics are like religious leaders.
No. Clerics are the judges of the Islamic countries. So their role is very limited to simpliciter, like how you have judicial clerks in India. The role is limited to following what the judges have said. So here in clerics as judicial clerics of Islamic countries, their role is simpliciter to follow what is said by the Quran and Allah.
So customs of land just means like the traditions and stuff.
Yeah, the customs are essentially which has been going on throughout the longest time. So generally, customs of land end up becoming laws, as that is something which has been going on for the longest time, and people have adapted that in their culture. Yes, everybody? Any doubts, any difficulties? Sure. Should we proceed then? All right. So the next chapter that we are going to start today is international law. Now you all have a brief understanding about what international law is because we studied that in the previous class. Now international law comes into picture. It is essentially the need of the hour only when there are conflict of laws. When the laws have a conflict with each other, international rules and regulations come into place. We will understand the need for international legal regulation in the context of conflict of laws, the functions of international treaties, conventions, and model codes, the role of international organizations such as the United Nations, ICC, World Trade Organizations, OECD, UNITROIT, UNICITRAL, and courts in the promotion and regulation of international trade. Now, why are these bodies so important for us to understand? Is because they are the ones who generally govern or show a guiding road to the implementation of international laws. Clear? Now, the operation and evaluate the distinct merits of the court-based adjudication and alternative dispute resolution mechanisms is something which is going to be a part of the syllabus. That is simpliciter arbitrations. Has anybody heard the term arbitration?
No.
Does anyone know what arbitration means?
I guess arbitration is deciding the, I mean, it's not going to the law, going to the court. There is the person who is appointed as the arbitrator and solve the disputes and give the punishment and all.
So arbitrations cannot be carried out for criminal matters. Arbitration is simpliciter that, for an instance, let's say Tanvi and I are in a business transaction and we both end up having a dispute. So what Tanvi and I decide is that rather than going to court and waiting for so long for our case to come up, for the entire process of law to take place, Tanvi and I decide, let's do one thing. Let's appoint Ishita as a common party who will be our arbitrator. So between Tanvi and me, we mutually decide to appoint Ishita as a third party who is a neutral party as an arbitrator. And then whatever decision which comes by Ishita will be binding upon both of us. So in arbitration, sometimes we may appoint a sole arbitrator like how Tanvi and I have appointed Ishita. Sometimes you appoint a group of arbitrators. That is either 3 arbitrators or 5 arbitrators. It's always going to be in odd numbers. The reason being that if there is a dispute between the arbitrators also, then the third person will be the one who will be the deciding factor. So when there are three arbitrators, obviously two will rule in one way and one will rule the other way, or all three will rule in one way. So the majority arbitrator's decision will be considered as the final binding decision. Are we clear, guys? Any difficulty up till now? So arbitration is something which we are going to understand. The process of arbitration, how it is started, how it is considered in this chapter, we will be dealing with it. We will be understanding the role of International Court of Trade, including International Court of Arbitration. Explain and apply in detail the provisions of unilateral model law on international commercial arbitration and the arbitral tribunal and the arbitral awards. Clear? So arbitral awards are equivalent to a decision of the court. So we can't simpliciter. This is for an example that I said that, Tanvi and I will appoint Ishita, but you can't simpliciter appoint any third person as an arbitrator. There are rules and there are, in that sense, specifications which are required, qualifications which are required for one to become an arbitrator also. And there is an entire law which needs to be followed while pursuing arbitration. Clear? We'll be dealing with that in detail in this chapter. Yes, Tanvi, please start reading.
Businesses from there?
Yeah.
Businesses are no longer limited to national or state boundaries. Trades or contracts occur between various countries. To make this global market a smooth, stable, and secure, one, there are several bodies, laws, and agreements in force. We will discuss some of such prominent bodies in this chapter. Need and sources for international law. When people are from a different legal systems trade, there are bound to be disputes sometimes, and since they have different legal systems, we have international law as a common system for all international businesses.
So it's very evident from the primary reading of international law that when people from different countries trade, of course, there are going to be disputes which arise, and there will be different legal systems which it will arise from. So let's say one country is a common law country and you're dealing with a country which is a civil law country. So there is entire, principally, fundamentally, there is a dispute and a conflict which will occur because in civil laws, judges don't interpret the law. In common law, judges do interpret the law, right? So in such situations, you will follow a mediocre process, a in-between process, which is international law. Yes, please continue with the sources.
Its sources are international treaties and conventions, international customs, general principles of law.
So again, self-explanatory. The international treaties are what? ये हम जो सुनते हैं, Modi ji has entered into a bilateral treaty with this country, a tri-party treaty with these two countries. So these are treaties and conventions which are actually a source of international law. Then international customs, like I had mentioned the last time also, if India and Nepal have trade relations from the longest time, then that those customs are then translated into international laws. And of course, the general principles of law. All right. And there are two types of international law: private international law and public international law. There's one typographical error which I want you all to change is ये public private law को change करके public international law कर दीजिए. Please change this public private law to public international law. Okay. Yes, please start reading.
Public and private law. Private international law, these are the domestic laws. Yes, they are basically laws about how will a country deal with international laws. They define in which cases and how much international laws overrule domestic laws and vice versa. Public international law, they are treaties, conventions, etc., accepted by various countries. It could be for trade, travel, military, etc.
So what is private international law? It is your country's perspective of international law. Your domestic laws which interpret and allow you to understand how much of international law will override and overrule your domestic laws. So this is your country's personal international law related laws. So how does India sees a trade with Dubai or a trade with China? That might not be up for public at large of all nations. So if today India says trade with China is banned, that is India's private international law which India has created. Whereas when I say there was a G20 summit which took place and all Asian countries participated. So whatever decisions which are taken in the G summit are public international laws because they are applicable to all those countries which are party to that treaty or that convention. Clear? Moving on. Yes, please read.
Conflict of laws. Conflict of laws will arise where the law of two different countries produces different outcomes, making it difficult for parties in those countries to trade with one another.
Again, we've understood what conflict of laws is. For an instance, non-repayment in India, the punishment is the simplicity of payment of 18% tax, interest. Probably in Japan, the rule could be that if you don't repay your vendors, your license to trade will get cancelled. So it could be a possibility that there are two different outcomes of a same dispute. So in such a situation, different parties would want to opt for different laws. And that's what will make it difficult for parties to trade with one another. Therefore, international laws comes into picture. Yes, please continue.
International treaties, conventions, and model codes. Public international law arises out of the problem of conflict of laws. Nations negotiate treaties and model codes so that the parties can refer to that agreed code of conduct while carrying out international trade rather than their own domestic laws. International bodies exist to help create, manage, and amend those agreed international laws.
So again, very simple to understand that public international law arises out of the problem of conflict of laws. Why would you need a public international law? Because if India and China have different laws, India and Pakistan have different laws, India and Sri Lanka have different laws. So in such situations, nations come together, negotiate amongst themselves, and agree to a model code which will have to be followed by all those countries, and that will override all your domestic laws with respect to that particular dispute and trade with that particular single country. Clear? Yes. Yeah. International bodies exist to help create, manage, and amend those agreed international laws. Of course. So these United Nations and all these bodies which are there, if there is a dispute with respect to the treaty which was agreed upon or the convention, then these guys, they intervene and they facilitate amendment and management of those issues. Clear? Now there's a quiz question. India, USA, and Australia sign a discounted tariff deal. Is it a private or a public law? Yes. Why it will be public?
Because it is between three countries, three different countries.
Correct. So it's between multiple countries, and therefore multiple countries are a party to this tariff, and therefore it's a public law. Clear? Now coming to the international organizations, I'm sure we all must have read a gist about all of this in our school times. Yes, in our civics textbooks, United Nations, the International Court of Justice, and everything. Yes, have you read them?
Yes, sir.
Yes. Please continue reading, Tanvi.
United Nations. The United Nations is a global body which has almost every country in the world as a member, which exists to maintain peace and security, develop friendly relations between nations, cooperate in solving economic, social, cultural, and humanitarian problems, to promote respect for human rights and international freedoms. Through its various subsidiaries, the UN has greatly facilitated international business. Its legal departments include UNCITRAL, the UN Commission of International Trade Law, ICJ, International Court of Justice, UNICTRAL, with its 61 member states, has passed several treaties and conventions and laws to make global trade more secure and efficient. It has 6 working groups.
So United Nations, if you all remember from your history textbooks, before United Nations, there was a similar organization which was set up, but it failed. And the failure of that was a reason why there was Second World War. After the Second World War, United Nations was set up to make sure that there is no Third World War ever. The United Nations is a global body which has almost every country in the world as a member. Everyone, most of the countries are members. The main goal is to maintain peace, security, develop friendly relations between the nations. So if you all remember any sort of international disputes that we've had in the recent past were put forth before the United Nations. Let's take an example of the Russia and Ukraine war that was put forth for resolution before the United Nations back in the time when one of our captains, Abhinandan, who was of fighter pilot, he was restrained by Pakistan. This matter was put forth before the International Court of Justice. And that is where we got an order and he was released overnight.
But sorry, I have a question.
Yes, sorry.
I have a question.
Yes, please tell me.
So if the United Nations is working so properly, why is there the war between Russia and Ukraine still going on?
So, sir, the United Nations is not a binding authority. So, I'll give you an example. If today I want to start a war against Pakistan, okay, I as in India, United Nations says, India, don't start a war against Pakistan. India is like, what if I do? What will you do? It's not a democratic country where you will pick up one particular person and put him to jail. Right? It's a whole country that we're talking about. So the only implications will be that you will be internationally boycotted. United Nations will ask all the member states to cease trade with you. They will cut down your transport, they'll cut down your trade, they'll cut down your economy in that sense. Import will be shut, export will be shut. So if you remember back in the time when Russia did not budge and initiated a war against Ukraine, the whole world condemned Russia. People stopped trades with Russia. People stopped supplies to Russia. But Russia is such a big superpower, it does not give a damn. So, bro, you do whatever you want to do. But eventually, of course, they had to surrender because of the diplomatic relations that they have with other countries. Right? So, it is just merely an international pressure which is created on you if you don't follow the United Nations, if you don't abide by the United Nations. But it's not something that they will send you to jail or something like that. Clear?
Okay, sir.
Because you think about it, if today there is one particular person or one particular group of people who are doing something wrong, as a country, you can put them in jail. But when the entire country is doing something wrong, what will you do as a third party? You have two options. One, either intrude that country and bombard that country, which again is against peace and security and friendly norms, or you boycott that country stop trade, you cut their legs and arms and fingers and restrict them and push them to a corner where they have to listen to you. Today, the reason why somebody like Russia can do this is because it knows that eventually with time, everybody's going to come back to Russia. For a matter of fact, India was one of the first countries who went back to Russia for trade. Why? Because India will think if 1 gallon, for an instance, is sold to India for 100 rupees, 1 gallon of fuel, petrol. If Russia is saying, I'll give it to you for 45 rupees, you'll be like, fuck international relations, bro. Give me the fuel. Very simple logic. At the end of the day, when Russia knows that it has so much of potential, that I can, why is it Russia called a superpower? Why is US called a superpower? Because one thing which happens in Russia or in UK or in, Russia or in US will affect the world market economy. At the time of the Russia-Ukraine war, your Nifty was down. Bank Nifty was down. Markets were crashing. Why? Did any bomb be blasted on you? No. Was anyone killed in India? No. Then why that happened? That happened because every country has its international presence. And its international presence impacts the other countries. So the role of United Nations is very important in such a way. Clear?
Okay, sir.
All right. So United Nations has separate wings and separate sectors. Like one is the ICJ, one is the United Nations Commission on Trade. One, you might all have somewhere or the other heard that, this is a UNESCO heritage site, World Heritage Site. So what is UNESCO certified? United Nations का ही एक wing है ना वो. So all these wings which are set up by United Nations, they come together in order to make sure that there is world peace and world harmony. Now, for y'all and for y'all syllabus and your careers, UNCITRAL, UNICITRAL, is very important. Why? Because the United Nations Commission on International Trade Law has set up certain modern rules and regulations. It's like a model which you have to adapt as it is. Of course, you can make your changes in that and all, but the draft is ready for you. Model rules and regulations are ready for you. You will follow those for your international contracts. Because if you're trading from, let's say, India and Japan, Japan will say, follow my rule. India will say, follow my law. Who will you follow? So you will then take the unilateral rules and regulations. Clear? Yes. Please continue reading the second part.
International Chamber of Commerce, ICC. The ICC is an organization created by business leaders from various countries which aims to serve world business community by promoting trade and investment, open markets for goods and services, and the free flow of capital. They help in ease of doing international business and also advise the UN. World Council is the chief authority of the ICC. World Council has an executive board of 15 to 30 members elected for 3 years, with 1/3 members retiring every year. They make ICC policies. World Council also elects a chairman and vice chairman who make recommendations to the board. National committees represent ICC in their national state. The secretariat, headed by the general secretary, ensure the implementation of ICC policies in the members.
So basically what they're trying to say is, it's like all a separate government which runs. Government में कैसे cabinet of ministers होता है, एक prime minister होता है. So the cabinet of ministers led by the prime minister, they are the ones who make sure that the country is running smoothly, right? Similarly, in ICC, they have the World Council, where all members come together, meet. It's like a parliament of their own. World Council is the chief authority of ICC. Now, these questions will come in your MCQs for 1 marker, 2 marker. Who is the dash is the chief authority of ICC? Option A, B, C, D. Or World Council is the chief authority of dash, A, B, C, D. So these are the questions which will come in. Who heads the World Council and who heads the Secretariat? So the Secretariat heads the World Council is the answer. Secretariat is headed by a General Secretary. Again, your answer. So such kind of MCQs can come up from this. So they have a executive board of 15 to 30 members elected for 3 years with 1/3 members retiring every year. Which other Indian body follows this system of retiring 1/3 members every year? Rajya Sabha.
Rajya Sabha?
Yes. Why does Rajya Sabha do that? Why do these guys do that? Why can't they just retire everyone after the end of 3 years and re-elect the new policy itself? Because they want there to be a continuation in the cycle. If everybody retires together and comes back, every new person members come back, then what will happen is it will be rebooted, reset. So to maintain continuity, 1/3 members retire every year. So at the end of 3 years, technically you will have a complete new electoral board. Clear? Yes. Next one, World Trade Organization. Please read.
The World Trade Organization is an organization which provides rules for the system of international trade. It was formed from the old General Agreement of Tariffs and Trade, GATT. The WTO provides guidance on trade in goods, services, inventions, creations, and intellectual properties. It has 149 members who are accountable for 97% of the global trade. Its board aim is to improve the global trade ecosystem. Appeals are heard by 3 members of the appellate body.
So again, the idea of World Trade Organization is to make sure that the trade across the world in goods, services, inventions, creations, and IPs is running smoothly. It has 149 members who are accountable for 97% of the international trade. So you realize why this is so important. Almost the entire trade across the world, international trade, takes place under the regime of World Trade Organization. Why do you go to World Trade Organization? When you have some disputes, when you have issues which are not being resolved, and then you get an order. If you want to appeal that, you again can appeal it before a body which is consisting of 3 members. Again, a good MCQ question. Appeals are heard by appellate body which consists of dash number of members. 1, 2, 3, 4 options A, B, C, D. So the answer will be C3. Clear? Yes, OECD.
Organization for Economic Cooperation and Development. The OECD is a group of member countries whose modern aim is to be forum for discussing, developing, and refining economic and social policies. It has 30 member countries and relations with 70 countries. It creates legally binding agreements.
What does OECD do? OECD is basically a forum for discussing, developing, and refining economic and social policies. When I say economic and social policies, what do I mean? I mean the trade inflow, the taxation on the trades, the cess on the trades, the charges on the trades, the movement and transportation, the customs, the duties which are levied on the trades, international trades. All of this is discussed here. It creates agreement between the member countries which are binding on the countries. Clear? Yes. Next.
International Institute for the Unification of Private Law. UNIDROIT is an independent intergovernmental organization, has 61 member countries, has 3-tier structure. The Secretariat carries on the day-to-day work. It's run by a Secretary General, the Governing Council, the General Assembly, decision-making body of UNIDROIT.
सेक्रेटरीट का स्पेलिंग करेक्ट कर दो, ई एक एक्स्ट्रा है वो निकाल दो. ठीक है. What is UNIDROIT? UNIDROIT is an independent intergovernmental organization. So multiple governments form a part of this body, with 61 member countries, has a three-tier structure. So this is also again a good your question, MCQ question. The UNIDROIT has a three-tier structure, which includes dash. So the Secretariat, the Governing Council, and the General Assembly. Clear? Yes. ICJ.
International Court of Justice. It is a subsidiary of the UN. It is not a court for individuals. It hears cases between two nations. It includes 15 judges. No two judges can be of the same nationality.
Now, ICJ, the name suggests it's International Court of Justice. But it does not mean that if you have a dispute with another country's businessman, both of you all will go to ICJ for resolution. No. ICJ only takes up disputes between countries, not individual entities, not companies, only countries. So if India has a river related dispute with Pakistan or Kashmir related dispute with Pakistan, India and Pakistan can both go to ICJ and get it resolved. Clear? Any doubts, anyone? Okay. Yes. The International Court of Arbitration.
The ICA is a body set up by the International Chamber of Commerce to oversee all aspects of the arbitration process when members refer disputes between them to arbitration.
We will delve into this deeper when we study arbitration, or else right now it won't make any sense to you all. But simplicity to understand that when people go to arbitration, when companies go to arbitration, when two parties go to arbitration, any disputes with respect to the appointment of arbitrator till the passing of the award, any disputes internationally can be taken up before the International Court of Arbitration. Yes. Moving on, we'll take a short break before we start with arbitration. We'll come back, let's say in 15 minutes. Okay. Let's resume. Let's resume, guys. Please switch your cameras on, everyone. Stephen, Suraj, Tanvi, Jay, Nakul, Drishya, Ayan, Jasneet. Okay, so now we are going to start with my personal favorite topic of your entire syllabus, which is arbitration. It's very interesting. It's something which keeps you connected to the law, but is also very, very different from normal practice that is going to courts. In this, it's simpliciter. You are wanting to resolve your disputes. You are wanting to find an amicable resolution to your disputes without going to courts, but by following the due process of law. So arbitration is, if simply put, let's say for an instance, Simran and we are in a trade, and there is a dispute which has come to our trade, and Simran and we decide that, see Simran, if we go to court, we are going to end up spending a lot of time, money, and we are going to be stuck in that entire process of legal jurisprudence. So rather, let's do one thing. Let's mutually agree to appoint one third party or a tribunal as an arbitration tribunal, and let's resolve our disputes over there. Whatever order, that is the award which comes in from the tribunal, will be considered as equal as an order of the court of law. So that will be faster, that will be efficient, and we can select somebody who has an expertise in the same area. Because we all know when you go to courts, you end up going before a judge, whether or not you like that judge to be the one to adjudicate the disputes or no. So in arbitration, you can on your own choose one authority, one person, one tribunal who may have an expertise in your area of dispute. All right. So there are a few prerequisites of arbitration. It does not work as easily and as smoothly as it appears, because there are certain prerequisites which needs to be followed. Starting off with the first thing is that an arbitration agreement. Both the parties need to agree to surrender the disputes before an arbitration tribunal. Now, how do you make an arbitration agreement? It can be a separate agreement where both the parties enter into that, saying that if any dispute arises with respect to the contract, we will subject ourselves to arbitration. Or it does not need to be a separate whole agreement. It can be one simple dispute resolution clause within your original contract itself. So the contract which we enter into at the time of discussing the purchase and sale, discussing the price, discussing the quantity, discussing the quality, that very contract you can enter an arbitration clause, and that one single paragraph will be considered as an arbitration agreement itself. So you don't need to separately make an agreement altogether. And the fun fact is that even if you have not entered into an arbitration agreement before your dispute is arising, after you realize that there is a dispute, you can still enter into an arbitration agreement. So arbitration is an alternative dispute resolution mechanism. All right. So in arbitration, it is not important if you've entered into the agreement before the dispute or after the dispute. Simplicity understanding is before invocation of arbitration. Before starting the arbitration process, you need to have an agreement in place. That agreement needs to be in writing and has to be agreed by both the parties. Clear? So what is the prerequisite of an arbitration? You need to have an arbitration agreement. As simple as it is. Now, once you make an agreement, what do you do next? Let's say in this instance, I was supposed to take goods from Simran and then deliver it to Nakul. So it was a back-to-back contract. And I have entered this in the contract that Simran, when you will provide me with goods, I will provide the same to Nakul. And when Nakul will pay me, I will pay you. So if Simran gets late by 1 month in delivering the goods, I will get late by 1 month in delivering it to Nakul. So if Nakul imposes any sort of charges on me for delay, I will impose the same on Simran. It's a back-to-back arrangement. All right. In such a situation, now Nakul goes ahead and invokes delay on me. And Simran says, I want my whole money. I have given you the goods. So I will tell Simran that, see, boss, the arrangement was back to back. Since Nakul has imposed the delay damage on me, I will impose the same on you. Or, for an instance, there is no delay by Simran. The Simran has delivered goods well within time to me, and I have delivered the goods well within time to Nakul. But if Nakul does not make the payment to me, then I will tell Simran, see, I have not received the payment, so I cannot make the payment to you. So we will then, Simran and I, if we both have a dispute, or Nakul and I, if we both have a dispute, either of the ways, I will make sure that the arbitration is invoked. Now, if in this instance, let's say Simran has delivered everything on time, but Nakul has not paid me. So I have to initiate arbitration against Nakul. So how do I initiate arbitration? Very simple. I will send a notice invoking arbitration to Nakul. So what was the first step? To make an agreement. Second step, to send a notice invoking arbitration to Nakul. Let's see, Nakul, you have not complied with so-and-so reasons. So-and-so issues have arisen. This is my claim. So now, if you still don't pay me my amounts, I am hereby constrained to invoke arbitration against you. And as per our arbitration agreement, what is that? That is the clause which was mentioned in the contract. Let's appoint an arbitrator. Nakul says, no, I don't want to appoint an arbitrator. You do what you can. What will I do then? Because arbitrator has to be appointed by mutual consent. Now Nakul knows that he's at fault, so he's not agreeing to appoint an arbitrator. Then what do I do? Should I appoint it on my own? But if I do that, then the entire crux of arbitration goes down to waste, because I have appointed unilaterally without Nakul's approval. So then how can I appoint anybody? Nakul will be like, you have appointed somebody of your choice who is going to be partial. Then, so in such a situation where I have sent the notice invoking arbitration, but the arbitration is still not invoked, I will go to court. And I will tell court that you don't need to interfere in any of the matters. You don't need to resolve anything. You just appoint one neutral arbitrator for me and Nakul. Then I will take up my matter before that arbitrator. So first step, agreement. Second step, notice invoking arbitration. Third step, if you both cannot mutually appoint an arbitrator, you go to court and you tell the court to appoint an arbitrator for you. So third step is appointment of an arbitrator. Clear? Up till now, the process is very clear.
Sir, in case of neutral arbitrator, are there 3 arbitrators involved?
So it totally depends upon what your agreement with the other party is. So if Nakul and I, we are unable to agree upon one single arbitrator, what we will do is, I say Nakul, चल ठीक है, तू तेरा एक arbitrator appoint कर, मैं मेरा एक arbitrator appoint करता हूँ. वो दोनों arbitrator को बोलेंगे कि तुम दोनों मिलके एक तीसरा arbitrator appoint करो. ठीक है? One more scenario. What if those two arbitrators also cannot agree upon one single arbitrator to be appointed? Then what will you do? It could be a possibility, right? Then again you go to court. Knock, knock. Only need one help. Appoint an arbitrator for me. Clear? Generally, when the arbitration is of smaller dispute, is of amounts relating to smaller monies, let's say 5 crores, 10 crores, then you appoint only one arbitrator. Why? Because 3 arbitrators, 3 times the fees. Arbitrator free में तो काम करेगा नहीं boss, है ना? So all arbitrators charge you that amount of money. But if it's, let's say, a dispute of 500 crores, 700 crores, 1000 crores, then you're like, boss, ठीक है, 2-4 crore इधर-उधर परवड़ेगा. Let's appoint one arbitrator each and let the both arbitrators appoint the third arbitrator. So that is as per your agreement. that you want to appoint a sole arbitrator or you want to appoint a tribunal with 3 arbitrators. What you cannot do is have a tribunal with 2 arbitrators. Why? Because if after the entire process एक आर्बिट्रेटर बोलता है कि ये सही है, एक आर्बिट्रेटर बोलता है गलत है, तो क्या करेंगे? Again loss, go back to 0. फिर then you go to court, तो makes no sense, no? So therefore you appoint either 1 arbitrator or 3 arbitrators. Now Nakul and I, we've appointed an arbitrator. ठीक है, by mutual consent we've appointed an arbitrator. पूरा process खत्म होने के बाद नकुल बोलते हैं मजा नहीं आया. This arbitrator is not favoring me, bro. Cancel. Let's go to court. Can Nakul do that? No. Nakul cannot then retract himself from the arbitration. Although what Nakul can do is, if during the process of arbitration, if any point of time Nakul feels that this arbitrator is partial, you know, like for example, Nakul and I together we have appointed Rishya as the arbitrator. And Drishya is favoring me because I teach her law. So Nakul is like, ये तो यार cheating कर रही है ये, सर की हेल्प कर रही है, अभी क्या करूं? पर मैंने तो कंसेंट दिया था Drishya को अपॉइंट करने के लिए. Now Drishya is being partial. Again Nakul can go to court, saying, see, this arbitrator is not behaving properly. You change the arbitrator. Then Drishya will be removed from the arbitration panel and a new arbitrator will be appointed. But of course, for that, there has to be reasonable grounds. You can't just be a SAR loser that because you're losing the matter, you're going to arbitration, to the court saying that change the arbitrator. Okay. So what is the process up till now? First point Z, क्या होता है सबसे पहले?
Agreement.
Agreement. Second point, Ritika. Ritika is watching Netflix. Yes, Ishita, second point.
Sending the invitation for the arbitration.
Invocation. Okay. Agreement, invocation for arbitration. Third point, Simran.
Appointing the arbitrator.
Appointing the arbitrator. Yes, Ronak, if I am not able to appoint the arbitrator by mutual consent, what do I do?
Go to the court.
Go to court, ask court to appoint the arbitrator for me. Now, both the parties have appointed the arbitrator. Arbitration has started, but one of the parties is not agreeable to the arbitrator. Then Tanvi, what will I do?
You cannot do that.
No, but if the arbitrator is partial, then if he is favoring one party, then what do I do? Then I again go to court and tell the court that, see, this arbitrator is behaving partially. He's favoring one party. So you replace the arbitrator. Okay. Now, once arbitrator is appointed, both of us are happy with the appointment of arbitrator. Then what will we do? Then since I am the one who has invoked the arbitration, I will file my statement of claim. I will write down everything on a piece of paper and I will say, see, this has happened. I had delivered the goods on so and so date. This was the contract. This was the timeline. Nakul has failed. So therefore, I am asking for X amount of money from Nakul plus interest. Okay. So I file my statement of claim. Now, Nakul says, I also have claims against you. That you delivered the goods to me on time, but those goods were of inferior quality. Bad quality goods. Or you are supposed to deliver 100 goods, you delivered only 40 goods. So, Nakul will also have an option to file a counter claim against me. So, agreement, invocation notice, appointment, statement of claim, counter claim. And if he does not have a counter claim, he will file a statement of defense. Okay. Then both parties will file their evidences. अब मैं बोल रहा हूँ कि मैंने ये डेट पे डिलीवर किया है, then I will have the delivery challans, delivery receipts, transportation receipts. If Nakul is saying he received only 40 items, then he will have that acknowledgement of only 40 items being received. Nakul might have written an email to me saying I have received only 40 items. Nakul might have approached me through a letter saying please send more items, the balance items. So for that, both parties will have to put in their evidences. After evidence, both parties will argue. And after arguments, the arbitrator will pass an award. Now, what is this award? This award is equivalent to an order of the court. So that award, once it's passed, it holds the same value as if a court has passed an order. Which court? So Jay has a question. He's asking which court do we approach for appointing of an arbitrator? Now, Jay, in India, for international commercial arbitrations, if you are unable to appoint an arbitrator, then you directly approach the Supreme Court by filing a petition under Section 11 of the Arbitration Act. All right. If it's
Suppose
arbitration,
both the traders are from different countries.
That's
And-
okay. Shouldn't matter. But you are from
So
one.
which court they will,
So
which court they will approach for appointing the arbitrator?
One of the trader is from India. The second trader is from Japan. If
Yes.
the trader who is from India is approaching the court for appointment of arbitrator, he will approach the Supreme Court of India. If the trader is from Japan who is aggrieved and wants to appoint an arbitrator, then he will appoint from Japan, the court of Japan. But in this, what's very crucial is that if the trader of Japan is appointing an arbitrator from the court of Japan, the place of arbitration also has to be Japan. If the place of arbitration is India, then irrespective of the trader being from India or Japan or anywhere, has to appoint an arbitrator from India only. So has to approach the Supreme Court only. Clear?
Yes, sir.
Now, sometimes what happens is, now Nakul is from Japan, I am from India. We are like, I say in India, he says Japan. What do? There is a issue. There's a wall which has been created, not able to get past it. What we say is, there is an international commercial arbitration center in Singapore, neither in India nor in Japan. So both of us decide to submit to SIAC, Singapore International Arbitration Council. So nation भी दूसरा, state जहाँ पे arbitration होगा वो भी दूसरा. So neither Nakul has a problem nor I have a problem. Clear?
Yes, sir.
So first is agreement. Second is notice invoking arbitration. Third is appointment of arbitrators. Fourth is pleadings. Pleadings माने statement of claim, counter statement, statement of defense, counter claim, जो भी है वो. Then evidences. And then arguments and finally the award. अब एक simple सा understanding है. Award आ गया. Now I want to challenge that award. Where do I go? Because we know that in courts, you always have an option that if you have received an order in a court, let's say a district court, you can go to high court. If you've received an order in a high court, you can go to Supreme Court. Arbitration, where will I go? So the answer to this is you have no recourse for appeal. Why? Because both of you all together decided to appoint somebody as a arbitrator. So you both had enough faith in that person. Now, if after this there is an option for appeal to go to court, then the whole process makes no sense. So, you will again go back to court. But there are a few exceptions in which you can go to court for setting aside, cancellation, nullifying the arbitration award. But they are very, very, very limited, restricted grounds. If the arbitrator has decided an issue and passed an award which is against the public policy of a country, then you can go to court. If it is with respect to disputes which cannot be surrendered to arbitration. अभी आज अगर मान लो कि ये दृश्या के पास गन है, उसने किसी का मर्डर कर दिया है, तो क्या उसकी फैमिली को बोलेगा चलो चलो आर्बिट्रेशन जाते हैं, अपन साइड में सुलटा लेंगे? Can she do that? If a couple wants to get divorced, They say, forget why to go to court. Let's go to arbitration and we'll get divorced. No. Can they do that? No. Only commercial disputes can go to arbitration. So there are certain criterias, only those disputes can be surrendered to arbitration, referred to arbitration. If the arbitrator has gone beyond the scope of that and passed an award, then that can be set aside by the court of that particular country. Now, if the arbitrator has been submitted to arbitration for a particular dispute with respect to the contract. Now, Nakul or Mera contract was with respect to 100 goods. ठीक है? Now, उसके बाद नकुल और मैंने और भी थोड़ा ट्रेडिंग किया है without any contract. And the arbitrator has included that trade also in a part of this arbitration. Why will that trade not be allowed to subject to arbitration? Because my arbitration agreement was limited to the contract which I had. So anything beyond the scope of that contract cannot be referred to arbitration. So अगर arbitrator ने उसके beyond जाके अगर decision दिया है तो वो भी मैं set aside करा सकता हूँ. So there are these few policies, few defenses on which you can set aside the arbitration award. Apart from that, you cannot set aside the arbitration award. Am I clear? Next is Nakul and I, Japan and India. We have got an award. Nakul has to pay me. Award says Nakul will pay Bhavya so and so amount. Bhai, abhi Nakul is gone, lost, gayab. How do I execute that? So I can execute it in Nakul's country. I can go to Japan and tell the Japanese court that, see boss, there is an award. If Nakul is not paying, you attach his property, you sell his property and you make the payment to me. The courts will do that. Because if the courts don't do that, then what is the whole point of arbitration? Correct? So this is the entire process of alternate dispute resolution. Agreement, notice invoking arbitration, appointment, pleadings, evidence, argument, award, execution and enforcement of award, or setting aside the award. This is the whole process. इसमें छोटे मोटे चीजें और आ जाती है, जैसे कि for example, if there is some typographical error in the award, there is some error, inadvertent error by the arbitrator. So you have time for 10 days, 15 days from the date of award or 30 days from the date of award, where you can seek the arbitrator that please amend this, please make this modification, error correct करके दे दो. That's it. This is your whole arbitration process. Very simple, very easy. A few detailings here and there, but something which you can memorize very easily. Now your home assignment for next week is to create a flow chart for the process of arbitration like how you created for the hierarchy of courts. ठीक है? Simpliciter ये जो हम जो points बोले उसको एक flow में, flow chart में you have to put it. Let's read the part of arbitration from our textbook. Yes, Simran, please start reading.
Certain basics. Under Article 1, Section 3, an arbitration is international if, at the time of the conclusion of the arbitration agreement, both parties should have their place of business in different states or countries. If parties to the contract expressly agree that the subject matter deals with multiple countries, a substantial part of the obligation exists in a different state than that of the parties. Under Article 3, any written communication will be considered delivered if it's delivered to the addressee personally, delivered at the party's place of business, habitual residence, or mailing address, If a party's place of business, habitual residence, or mailing address cannot be determined, the written communication will be considered delivered if it is delivered to the addressee's last known place of business, habitual residence, or mailing address.
All right. So again, this is with respect to how to communicate your arbitration notice invoking arbitration. Clear? Now, any difficulties up to now? I don't want you all to understand, memorize these sections and articles. We are good without that, but you all need to know the process very correctly. Okay? Any doubt up till now? Any difficulties? Delivery कब गिना जाएगा? When will it be counted as an effective delivery? When the notice invoking arbitration reaches to that party. Clear? Yes. Next.
The communication is deemed received on the day it is delivered. The relevant court or authority is the one regarded in the country of arbitration.
Again, like we discussed, that wherever the venue, the seat of arbitration is there, that country will be the court where you have to go for arbitration issues. Correct? Yes. Now over here, we are done with the delivery of the notice invoking arbitration. So now we have to do what? You have to appoint the arbitral tribunal. Yes? Yeah. Continue reading.
Arbitration tribunal, the number and procedure of selecting the members of the tribunal can be decided by parties concerned. If the parties are unable to appoint arbitrators, there will be 3 arbitrators. Nationality won't be a barrier to an appointment on the tribunal unless the parties agree upon otherwise. If the parties can't agree on a process to appoint arbitrators, then both parties will appoint 1 arbitrator each. These 2 arbitrators will then assign a 3rd arbitrator. If a party or the 2 arbitrators fail to make necessary appointments within 30 days of being requested to do so by the other party, the relevant court or authority will make the necessary appointments. Challenging the appointment to the tribunal, a party is convinced that an appointment to the tribunal could be partial, not independent, or unqualified as per the agreement. This appeal must be made to the tribunal within 15 days of being informed of the appointment. If such a claim is rejected by the tribunal, the party can challenge the decision in a relevant court within 30 days of the judgment. The decision of the relevant court shall be final and unchallengeable. The tribunal will continue functioning when the relevant court is still deciding on the challenge. A party can request the removal of an arbitrator even if he has appointed the arbitrator himself. If an arbitrator resigns, then a new arbitrator will be planned using the same process as earlier.
All right. So this process is clear, everyone? How to appoint, how to challenge the appointment and all of that? Yes, any doubts, anyone? Okay, let's proceed. Yeah, arbitral proceedings.
Arbitral proceedings. A plea of improper jurisdiction of the tribunal must be made by a party before presenting the defense statement for the issue under arbitration. A plea about the tribunal overstepping its jurisdiction must be made as soon as the specific incident takes place. Even if the party does not agree to certain procedures, the tribunal will carry on functioning as it sees fit, though each party is treated equally and has the right to set the pace of the tribunal. The parties can decide the language in which the arbitration will be conducted. If they cannot agree upon a language, the arbitrator will decide the language. All documents submitted to the tribunal and the documents used by the tribunal to reach the judgment shall be communicated to all the parties. If any party fails to appear in a meeting or fails to provide documentary evidence, the tribunal will function normally and announce judgment based on available evidence. Unless otherwise agreed by the parties, if a party fails to make a statement of claim without proper reason, the tribunal will terminate proceedings.
So again, this is basically elaborating the part which we had discussed with respect to statement of claim, statement of defense or counterclaim, evidence, and all of that. Right? Any difficulty with understanding this now? The only part, the seventh point, it says that if a statement of claim which is made by me as a claimant does not make any sense, then the arbitration will be terminated immediately. They will not wait for going to the last stage of award. Clear? Now, the award which I receive after the completion of the arbitral proceedings, what are the features of that award? Yes, please read.
Features of arbitration award. It is the final decision of the arbitration tribunal. It is passed by a majority vote of the tribunal. If the parties agree upon a settlement during the proceedings are concluded, and on the request of the parties, the tribunal could pass the agreed settlement as the arbitration award. The award is in writing and signed by all the arbitrators. Rules for correction of arbitral law. Either party may seek correction within 30 days of the award being announced. If the tribunal considers the request justified, it will make the required corrections within 30 days of receiving the request. Additional awards for claims made during the arbitration can be made within 30 days of award. If justified, the tribunal will make such an award within 60 days. An arbitration award may be relegated by a relevant court only if
Relegated
arbitration
means cancelled or set aside.
An
Yeah.
arbitration award may be relegated by a relevant court only if arbitration agreement was invalid, appealing party was not given due notice of the appointment of arbitrators, the award is beyond the jurisdiction of the tribunal, the award is contrary to public policy.
So like I told you, there are only few reasons why an arbitration award can be challenged and set aside. And these are the 4 pointers. Clear? Moving on to, now that the award is passed, now we'll discuss about recognition and enforcement, the execution part. Correct? Yes, please continue.
Recognition and enforcement. Under Article 35, regardless of which country the arbitral award was made in, it will be recognized as binding and, upon application in writing to the court, shall be enforced subject to the provisions of Article 36. Under Article 36, recognition or enforcement of an arbitral award, irrespective of the country in which it was made, may be refused only at the request of the party against whom it is invoked, if that party furnishes to the competent court where recognition or enforcement is sought proof that a party to the arbitration agreement referred to in Article 7 was under some incapacity, or the said agreement is not valid under the law to which the parties have subjected it, or failing any indication thereon under the law of the country where the award was made, or the party against whom the award is invoked was not given proper notice of the appointment of an arbitrator.
Yeah.
Or of the arbitral proceedings, or was otherwise unable to present his case, or the award deals with a dispute not contemplated by or not falling within the terms of the submission to arbitration, or it contains decisions on matters beyond the scope of the submission to arbitration, provided that if the decisions on matters submitted to arbitration can be separated from those not so submitted, that part of the award which contains decisions on the matters submitted to arbitration may be recognized and enforced, or the composition of the arbitral tribunal or the arbitral proceedings was not in accordance with the agreement of the parties, or failing such agreement was not in accordance with the law of the country where arbitration took place, or the award has not yet become binding on the parties, or has been set aside or suspended by a court of the country in which or under the law of which the award was made, or if the court finds that
Okay,
the subject.
before you move ahead, now at a request of the party against whom it is invoked, that is the respondent in the arbitral proceedings, the party furnishes to competent court when recognized enforcement suit is sought, meaning where I am going for enforcement, whichever court I am going for enforcement, if after going to that court, it is understood and realized that the arbitration agreement referred to in the Article 7 was under some incapacity. That means that the arbitration agreement was only not valid in law. Then you will not be allowed enforcement. If the party against whom award is passed was not given proper notice, which notice? The second pointer which we had done, notice invoking arbitration. If that notice was only not given, then again your arbitration will not be enforced. Your award will not be executed. If at all the award deals with a dispute, like I told you that there are some disputes which cannot be submitted to arbitration or are beyond the scope of arbitration, like matrimonial disputes, murder and all of that. If the dispute pertains to one of those reasons, then again that award will not be executed. Or if the composition of arbitral tribunal was not in accordance to the agreement, if the agreement says you have to appoint only one arbitrator, but you appointed 3 arbitrators, or vice versa, then again your arbitration award will not be acceptable. The award has not yet become binding on the parties or has been set aside or suspended by a court of a country in which the arbitration award was made. So ये क्या बोलना चाह रहा है कि basically अगर इंडिया और जापान के बीच का arbitration हो रहा है सिंगापुर में, अगर सिंगापुर में award आने के बाद I went to Japan to execute that award and Japanese court said I cannot enforce this award. So what I do is then I come back to India and then file for execution in India. So then immediately, because one court has denied execution, this court will also dispute the award. Clear? Or if the court finds that subject matter of dispute is not capable of settlement by arbitration in the law of the state, like I said, matrimonial disputes, murder, all of that, then court will reject the recognition or is contrary to public policy. Again, then it will reject the enforcement of arbitration. Is the concept of arbitration clear, everyone? Guys, any doubts, any difficulties, you can ask me right away. Should we proceed? The last part of this topic, which we're going to study, is the advantages of arbitration over the courts. Guys, switch your cameras on. Jay, Tanvi, Ronak, Stephen. All right. So the advantages of arbitration over the court is what? That it gives speedy recourse, very fast, cost efficient. There is privacy in court. Anybody and anyone can come and observe what the proceedings are going on. Arbitration is very private. Informality, because it is not a proper court, the formalities are less. Expertise, like I said at the very start, you can appoint an arbitrator of your expertise. And neutrality, arbitration can take place in a neutral country. You don't need to go to one of the countries of the parties. Clear? Now, the advantages of courts versus arbitration. Of course, it's not that only arbitration has advantages. Courts will also have some sort of advantages. Now, what are the advantages? The advantage is that the judges of the courts are highly experts of law. So legal points, they understand better than the arbitrators. Arbitrators might be experts in your subject matter, but the expert in law is always the judges. Courts work on pre-established law and precedents, judicial precedents. And judgments are more predictable because of judicial precedents, you have an advantage over there. There is more scope of appeal in a court case. Like I said, in courts, you always have room for appeal. In arbitration, you don't have that much of room for appeal. Are we clear? Yes, guys? Any doubts, any difficulties, anyone? So you all will be able to figure out the flowchart for arbitration by next week. Yes? Okay, all right. So we'll wrap up the class for today.
Yes, sir.
Anybody, any doubts? Any concepts that you want me to revisit? Okay. Great, guys. Cheers. How did you all like the class today? Interesting, boring, partly interesting, partly boring.
Little interesting than yesterday.
More interesting yesterday. Oh, nice.
नहीं, little interesting than yesterday. मतलब today's class is more interesting.
That's what I'm saying. I agree. So, all right, guys, you all will get a feedback form after the Zoom. Please fill that and write as many bad comments as you can, because I will get to know who has written it. All right. Okay. Cheers, guys. I'll see you all next Saturday. Next Saturday we are off for Diwali. So we'll meet after the weekend, that is around 6th, I guess, right? No. Oh, 8th. 8th. We'll meet on the 8th of December. Okay?
Okay, sir.
November.
November. Sorry, my bad. 8th of November. All right, guys. So see you all. Cheers. Wish you all happy Diwali. Have great fun, great memories. Don't forget to make my arbitration chart, or else I will light up dias in your asses.
Okay, sir.
Cheers, guys. Have fun. Bye bye. Enjoy your Diwali
Bye,
break.
sir.
And
Happy Diwali, sir.
well, have a
Happy
safe.
Diwali, sir.
Thank you. Thank you, all of you all.
Thank you, sir. Bye.